Ms. Ortiz,
Yes, sir.
please put your mic on mute. We will be starting our arraignment in a few minutes. And once we finish the arraignment, we'll give you a court date.
Yes, sir.
Thank you. Good morning, ladies and gentlemen. I'd like to welcome you to County Court Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court Law Number 2. This morning we have an arraignment, and what the arraignment is just an opportunity to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. Now, if a person is convicted of the state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of the third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary. If a person is convicted, 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those types of punishment because, as I mentioned to you earlier, your case is a misdemeanor case. Misdemeanors are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is fine only. You cannot be given jail time. You only can be given a fine. And the fine cannot be above $500. Now, Class C misdemeanors are cases that start in the city court or the JP court. They only come to this court when the person is either found guilty or person enter a plea of guilty and no contest in the JP court or the city court, and they appeal their case. In essence, they want a whole new trial. They get a whole new trial and it comes to this court. The range of punishment does not change. It's still the same, which is a fine only, and the fine cannot exceed $500. Now, if they fail to pay the fine, or if the fine was converted to community service, and they fail to perform the community service, then the court can issue what is called a capious pro fine. What that is, it's a warrant for their arrest for them to either pay the fine or sit the fine out in jail. If they sit the fine out in jail, for every 1 day that they are in jail, they'll be credited $100 that will go toward the payment of the fine and court costs. Okay. Now, the next highest misdemeanor, that was a Class C misdemeanor. The next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and the fine. The highest misdemeanor is a Class A misdemeanor. With a Class A misdemeanor, the range of punishment is minimum 0 days in the Jefferson County Jail, or it could go from 0 days to 365 days, which is a year in the county jail. Or you could be given both, or you could be given a fine that does not exceed $4,000. Or you could be given both the fine and the jail time. Okay. Now, the paperwork that you have in your hand, I mentioned to you earlier that we are going to talk to you about the rights that you have. I'm going to go over those rights with you. Okay? In fact, the paperwork that you have in your hand on the clipboard, I'm getting ready to go over that paperwork with you right now. Now, you should have a little short form. We're not going to fill out that form. That's for we'll talk about that later on. But the first form should be titled Judge's Explanation of Rights to Defendants Without Attorney. And the document looks like this. Okay? Now, I will continue to refer back and forth to this document. Okay? And so we're going to constantly refer back and forth to this document. So this document, Judge's Explanation of Rights of Defendants Without Attorney, states that as a defendant in a criminal case, this is a criminal case, you have 3 options. They have them listed here. Number 1, you may hire an attorney. Number 2, you may request that an attorney be appointed to represent you if you cannot afford to hire an attorney. And number 3, you may represent yourself. Okay. Now, the first sentence under number 3 states that if you want an attorney and you can afford to hire an attorney, your case will be reset. Reset means that you will be given another court date different from the day to give you time to hire your attorney. Now, the next one sentence paragraph below number 3 states that if you want an attorney, but you do not have enough money to hire an attorney, you may ask that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. The financial questionnaire is a 3-page document that is on the clipboard. It is titled Jefferson County Affidavit of Indigence, and it looks like this. Now, you will only fill out this form if you are applying for a court-appointed attorney. If you are not applying for a court-appointed attorney, you don't have to fill out this form, and you don't have to listen to anything that I'm getting ready to say about this form. All right, this is only for people who want an attorney but cannot afford to hire an attorney. All right, now, for those individuals, you would have to fill out the first page of this document, the entire first page. You're going to ask for your name, your address, whether you work, you don't work, if you work, your finances, if you have bills. That's all on here, on the first page. On the second page, you have to fill out the top portion. It says defendant's oath at the top. It says defendant's oath. You would have to fill out this little portion, right? It asks, the only thing it asks for the day's date and your name. Okay. And the middle portion, you would have to fill that out. It's titled Unsworn Declaration by Defendant, and then you'll stop. Okay. Now, going back to the first form, Judge's Explanation. The third paragraph, the third one-sentence paragraph below number 3, it states, you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. What that means is this. First of all, this is only for people who will be representing themselves. If you're representing yourself, you are your own lawyer. And just like your lawyer can talk to the district attorney, assistant district attorney, guess what? you can talk to the assistant district attorney. Why? Because you're your own lawyer. You represent yourself. And you can talk to them about your case. To see if y'all can work out what is called a settlement, or we call it a plea bargaining agreement to settle your case. Now, but this sentence says that you may not speak to the prosecutor about your case unless you first sign a waiver of your right to be represented by an attorney. Now, the waiver is a one-page document that is also on the clipboard. This is only for people who will be representing themselves. If you are not representing yourself, you don't have to worry about signing this. So if you are asking to hire your own attorney, you don't have to sign it. If you are asking for a court-appointed attorney, you don't have to sign this. Only if you are asking to represent yourself will you have to sign this document that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Now you would have to fill out the first page. You have to fill, it's only one page. You have to read the entire page, sign and date. Okay, now for those individuals who will be representing themselves, this paragraph in block form states that be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of firearms, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you are representing yourself, guess what? You may change your mind at any time. For example, I mentioned to you, well, let me do this here before I get to that. As a defendant in a criminal case, I told you about the range of punishment, what a class A is, class B, and class C. Now, you may qualify for probation. There are two types of probation. One type is called unadjudicated probation. Unadjudicated probation basically means that you will not have a conviction on your record. And guess what? If you complete your probation, you will not have a conviction on your record. Your case will be dismissed, and you may qualify for a non-disclosure. A non-disclosure basically means that your record is sealed to the general public. I say the operative word is general public. So the general public cannot unseal your record, unseal that record. For example, let's say most of the public is general public. Let's say you applied to a job at ExxonMobil and you have a non-disclosure, your record is sealed. Guess what? They can't see it. They can't see it. They can't unseal it. So they will not be aware that you are the first adjudication for this case. That's what sealing is. Now, if you do not, well, if you fail, well, you should be aware. Now, I say the operative word is the general public. There are agencies listed in the Code of Criminal Procedure, like the police department. They can have access to it. But it's only those governmental agencies that are listed in the Code of Criminal Procedure that can have access. But most of the public is what? General public. So a lot of times you're on a job, it's not governmental related, they cannot have access to your record. Now, the next type of probation is called adjudicated probation. We commonly refer to it as regular probation. It does result in a conviction on your record, but there's something that is called judicial clemency. Judicial clemency is where the judge can set aside the conviction, right? And you will no longer have a conviction. And because you no longer have a conviction, it's almost like it never happened. Okay? And so you will no longer have this conviction on your record. It's almost like you will be given a pardon. It's similar to that. It's not the same thing, but it's similar. Now, however, if you get a subsequent conviction. That is, if you get another conviction later on, the case that you received judicial clemency on can be resurrected, can be brought back up, and it can be used against you. And if you try to get a license with Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend a license. I've said all I have to say this. Let's say we was talking about you representing yourself, right? And you being able to change your mind at any time. Let's say you want unadjudicated probation, which means that with the unadjudicated probation, you don't have, that's what you won't have this conviction on your record. And let's say you represent yourself, you talk to one of the prosecutors, this criminal district attorneys, we got two of them here. And they tell you, well, we're not gonna offer that, we're gonna offer you, a fine and court costs. And you say, well, I don't want to fine and court costs. If that's the case, you can say, well, Judge, I changed my mind. I want a lawyer to represent. Okay? I want to see if I qualify for court-appointed attorney. You can do that. Okay? You can change your mind. That's basically say that last sentence says that if you are representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, in bold print, it states defendant's choice. Okay? It's right here. Everybody is right here. Defendant's choice. Everyone is going to make one choice. Everybody here for a case. So, if you would like to hire an attorney, then you'll place your initials on the first line to the left. Okay? At the bottom of this document. You will sign where it says defendant. You will date it today's date, June 16, 2026. And guess what? This is the only form that you would have to sign when you finish. Sign it. Okay. If you have already hired an attorney, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. Then you'll sign and date it today's date, and this is the only form you'll stop. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. All right, at the bottom. You'll place your initials on the third line, you will sign, date it, and then you'll go to this form that is titled Jefferson County Affidavit of Indigence. You'll fill out this entire first page. You'll go to the second page, start it, and then you'll fill out the top portion that's titled Defendant's Oath, and the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. If you have already been appointed a court-appointed attorney, then you'll place your initials on the fourth line to the left at the bottom, if you've already been appointed a court-appointed attorney. And then you'll sign and date it at the bottom, and this is the only form that you have to sign, and then you'll stop. If you would like to represent yourself, then you would have to put your initials on the last line at the bottom, the fifth line, sign and date it, today's date, and then you'll fill out the form that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding this trial. You'll read and sign this, and then you'll stop. Okay, do we have any questions? Okay, and at the end, if you need any help filling out the forms, our court personnel, including myself, will be able to help you to fill out the forms if you need help, okay? All right. Now, the next thing I need to talk about is you can enter a plea of either not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. No contest means that you will not be fighting or you will not be contesting the charge. Okay, so you have a right to have a trial by jury. But those young people are sitting in that box, we call it the jury box. They're sitting over there in those chairs. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence that's presented by the state in the defense. They will listen to the arguments of the state in the defense, and then they will go back into the jury room to deliberate, to decide whether to find you not guilty or guilty. You also have the right to waive or give up your right to have a jury trial. Now, you still can have a trial. It just will not be a jury trial. You can have what is called a bench trial. And what a bench trial is, it means that, well, first of all, it's a trial by judge. The reason why they call it a bench trial is because the judge sits on the bench. So they call it a bench trial. And so the judge will be the judge and the jury in the case. The judge will listen to the evidence that's presented by the state and by the defense, the arguments of the state and the defense, and then the judge will apply the law to the facts, or the facts to the law, and then decide whether or not to find you not guilty or guilty. Now, if you do not want to have a trial by jury or trial by judge, in essence, you want to enter a plea of either guilty or no contest, which guilty is saying you did it, no contest saying that you did not do it, and you want to see if you can work out a plea bargain agreement to settle your case, then you will talk to the prosecutor, or your attorney will talk to the prosecutor, see if y'all can work out something. If you are able to work out something, that y'all have an agreement, we call that an agreed plea bargain. Then that agreed plea bargain will go before the judge. The judge can do one of two things. The judge can accept your agreement or reject your agreement. Let's say, for example, you wanted unadjudicated probation. Let's say the state offered you unadjudicated probation. And then say it goes before the judge. Let's say the judge said, well, I'm going to reject that agreement. Well, you say, well, judge, if you reject the agreement, I take back my plea of guilty and no contest. That's it. In essence, I'm not pleading guilty and I'm not pleading no contest. You have a right to do it. Okay? Now, if the judge follows the plea bargain agreement, and let's say within 30 days, you would like to appeal your case because you have 30 days to appeal your case, you have to get permission from the judge that followed the plea bargain agreement. And if the judge gives you that permission, guess what? Your case will leave here and go right upstairs to the Ninth Court of Appeals. There are 4 judges up there. They will review your case. They can either grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty and the case is over. Or they can send the case back down to this court with orders. Or if they deny your appeal, guess what? You can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the Texas Court of Criminal Appeals located in Austin, Texas. It is the highest criminal court in the state of Texas. Now, you would have to file what is called a pro se petition for discretionary review. I'll explain it to you. Pro se means self. I'm representing myself. Okay? I am a lawyer, but I'm representing myself. And I'm asking the Texas Court of Criminal Appeals to review my case. Why? I want to see if my appeal should have been granted. Or to see whether or not this court committed an error by convicting me. They can do one of two things. They can grant or deny your petition. If they grant your petition, then they can simply find you not guilty and the case is over. Or they can, if they deny it, well, or they can send it back to the Ninth Court of Appeals, or they can send it back here with orders to the Ninth Court of Appeals and with orders to this court. Now, if they deny it, at that point, your conviction will stand. Okay. Now, the next thing we need to talk about, you see that kid that has a microphone in front of it? We call it the witness stand. And what witnesses do, they testify. In essence, they'll come to court, they can testify for you or against you. If you represent yourself, you could ask the questions. If you have a lawyer representing, your lawyer can ask some questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses. If you waive or give up the right to have witnesses, that means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. Okay? Now, you also have what is called a Fifth Amendment right against self-incrimination. I'll explain it to you. The Fifth Amendment of the United States Constitution gives us the right to remain silent. Right? In essence, what that means is the state, the government, the DA's office cannot force us to take the witness stand and testify against ourselves. Right? So you have a right against self-incrimination. And if you think about it, it makes sense. Why? Because the state has the burden to prove that you're guilty. You don't have to prove yourself guilty. Okay, so you have a Fifth Amendment right against self-incrimination. I know a lot of times we watch television and we see the television lawyer go up to the witness stand and ask the witness a question, and the witness say, I take the fifth. What he's saying is, I'm exercising my Fifth Amendment of the United States Constitution. I'm not saying anything. Okay, you have a Fifth Amendment right against self-incrimination. All right. Now, the next right that you have that I want to talk about is your right to have discovery. Discovery means that you have a right to see the evidence. You have a right to see the evidence that the state has in its file against you, okay? That's called discovery. I guess they call it discovery because maybe you discovered it for the first time, but they call it discovery. So you have a right to see your statements, witness statements, police reports, lab reports, photos, audio, video recordings. You have a right to listen to audio recordings, see documents and instruments, whatever they have. You have a right to have access to that. That's called discovery. Now, you can waive or give up your right to have discovery. If you do that, that simply means that you will not be having access to it. Now, everybody that's here for a case, you've been charged, you've been arrested, you bonded out of jail, and you're out of jail either on a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you pay the percentage of the bond to get out of jail because you paid the bondsman, or you're out of jail on a PR bond or a personal recognizance bond, which means that you did not have to pay the money to get out of jail. You were just simply released under your own personal recognizance. Now, I've said that to say this. Every day that you spent in jail, it can be used as credit towards your punishment. The operative word is every day. Let's say you were arrested not arrested, but you were booked into jail at 11:59 p.m. last night. And let's say you booked out of jail 2 minutes later, 12:01 a.m. this morning. That's 2 days. Why? It's 2 minutes, but it's 2 days. The reason why it's 2 days because one day was Monday and the other day is Tuesday. Okay? So every day that you spent in jail can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail. Let's say you talk to the prosecutor, they offer you to serve 5 days in jail. Guess what? You don't have to serve any more time in jail. Why? Because you'll be given credit for the time that you already served. It's called credit for time served. Now, let's say the state is offering 7 days in jail. You spend 5 days in jail. Guess what? You only have to spend 2. Why? Because you already served 5. We take 5 from 7. That leaves 2. Okay. Now, every day that you spent in jail also can be used as credit towards your fine and court costs. Every one day that you spend in jail, you are credited $100 that will go towards your fine and court costs. So if you spend 5 days in jail, that's $500 that can go towards your fine and court costs. So if they offer you fine and court costs of $500, guess what? You don't have to pay anything. Why? Because the 5 days you spent in jail has already paid them. All right? Now, if they offer 7 days in jail and you already spent 5, and that's $500. If they offer, say, a fine and court cost of $700, that's what I meant to say. And you spend 5 days in jail, you have $500. You take $500 from the $700, that leaves 2. That means you would have to pay $200 on the day that you take care of your case. But guess what? If you cannot pay it, it's no problem. Why? Because we could put you on a payment plan where you can pay it off in small monthly installments until it's paid off. If you cannot pay it off, let's say you don't have the income, you don't have a job, no problem. We can convert it to community service. And so for every 1 hour of community service that you perform in a nonprofit organization, you will be credited $12.50. Almost like worth $12.50 an hour, but anyway. So if you work 8 hours one day, 12 hours, $12.50, guess what? That's $100. So you work 2 days, 2 8-hour days, you owe $200, guess what? It's already paid off. And your fine and court cost is paid off, okay? The other thing I need to talk about is Jefferson County has a program. And when I'm talking about Jefferson County, I'm talking about the DA's office. It has a program where they will dismiss your case. And it would not be on your record, and they'll get it, you can get it expunged off your record, like it never happened. The program is for first-time offenders. They call it pretrial diversion. So if it's your first time getting one or more cases, all of a sudden, you know, somebody once say when it rains, it pours. Sometimes you got in trouble, next thing you know, you got all these cases. First time, they have a program called pretrial diversion, where if you get in the program, complete the program, they will dismiss the case and you can get it erased, wiped off, or deleted, which is called expunged from your record. Now, in order to qualify, 3 things has to happen. 1, it has to be your first time. Okay? 2, you have to have an attorney to help you with the application process. The attorney could be appointed or hired, either way. Or they can do pro bono, either way. And the third thing, it cannot be an offense for unlawful carrying a weapon or resisting arrest. For all other offenses, you can qualify for pretrial diversion. And again, you get in the program, complete the program, then we'll dismiss the case and get it wiped off your record. All right. If you are a veteran of any one of the branches of the United States military, right? They have a the district attorney's office has a program that is called Veterans Court. With the Veterans Court program, it's similar to it's part of the pretrial diversion program. You get into the program, complete the program, they'll dismiss the case, and then you can get it wiped off the record. And now, in that program, I don't think there is it's for all cases. It's not just, it doesn't exclude unlawful carrying a weapon or resisting arrest. All right. Now, this court, County Court at Law number 2, has a program that God led me to start within the first 100 days of taking office in March of 2017. The program is called the CSI program. CSI is an acronym, CSI, that stands for Community Safety Initiative. The program is designed to address the issue of recidivism. I'll explain what recidivism is. Recidivism means when people are committing crimes over and over. So how do we address that? Well, we address it through our Community Safety Initiative. In that program, we have partnerships with various agencies. One of the agencies that we have a partnership with is the Spindletop Center. And we have some folks from Spindletop Center in the Sheriff Department who will come to you in a few minutes and tell you a little bit more about the program that Spindletop has. Now, Spindletop is our local mental health center in our Southeast Texas region. They have the expertise for doctors, counselors, mental health officers, and a plethora of individuals who have expertise in mental health. They can address your mental health issues. You don't have to be incompetent or insane to participate in the program. You can just merely suffer from depression or anxiety or any other host of mental illnesses, and they have the expertise to address your mental health needs. Now, what they will do here today, they can do a private interview either in our jury room, at their facilities, by telephone or by text, whichever is convenient for you. Then they can develop, they can do what is called an assessment to determine what your mental health issue is. And then after that, they can develop a treatment plan to address your mental health issue. It could be outpatient or inpatient. If you have problems with drugs or alcohol, well, Spinotop has a program that is called ATAR. It's an acronym ATAR that stands for Addiction, Treatment, and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OZAR. It is also an acronym that OSAR that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do, they could do a screening, which is an interview, an assessment to determine what your drug or alcohol issues are, and they could develop a treatment plan for either outpatient or inpatient treatment to address your drug or alcohol issues. If you are unemployed or looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training program and a job placement program in the hotel industry, the shipping industry, or the chemical industry. And once you are trained in any one of those areas, they will help you to get a job in the area that you're trained in. Now, if you haven't graduated from high school, or if you do not have a GED, they have a GED program. Spinotop has one as well, where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we don't just give time. We take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law No. 2 of Johnson County, Texas, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community. Why? Because what comes out of the home goes into the community. So if you're interested in any one of these programs that I just mentioned to you, and you would like to get on the road to living your best life, just let us know. And we'll direct you to the individuals that you need to talk to get on the road to being the person that God made you be. Okay, so at this time, we have some folks from our Spinotop and our mental health Deputy Butler and Tanya. They're gonna come and tell you a little bit more about the program that Spinotop has to offer. You are.
Good morning, everybody. Deputy Butler with the Jefferson County Sheriff's Department. I'm one of the liaison officers that works along with Spinotop. This is my partner, Ms. Latanya. She's a qualified mental health professional. If you so become a client for Spinotop, she'll be one of the ones you'll be speaking with Friday. Now, I place heavily on Friday because what it said between you and her or any other qualified mental health professional is kept between y'all. Due to the HIPAA law, they won't violate anybody's rights. If you became a Spinotop client and you need to get to a doctor's appointment or you need to get to an intake appointment, me along with two other mental health deputies will give you a ride there if you don't have them. So there's also other sources being offered out there that mental health deputies can get you with those things. But if you become a mental health, you become a client, then you will speak with Ms. Latanya first before you will get you connected to find out which type of source of help you might need at that time. This is a voluntary deal, you're not being forced to do this, on your own time. It's just another, source of help we can offer out to you. You latch onto it, it will help you. Ms. Latanya, she'll tell you more about the stone talk program.
I want you guys to wait that form that Judge Holmes and that you was explaining. It is totally optional, but if you guys do decide to fill it out, I can meet you guys today here. I'm also available by text message or email. It just depends on what services you guys are trying to get help with. If it is substance abuse, we have classes on campus that we can get if you guys signed up for. As Deputy Butler says, if you have appointments set and you're not able to make transportation, or if you're not able to keep the appointment physically, we also have online services. If you do decide to fill out the form, as I said, I can contact either way, whichever is available best for you guys. If we have any questions, I can speak with you outside in the jury room, whichever is comfortable for you. Thank you. Thank you.
Okay, thank you, Tanya, Deputy Butler. Now, Tanya, Deputy Butler is probably a little modest, but I would just say that, since the program has been in effect, hundreds of people have been helped, by Spinoza. And so, they're doing a great job. And, like I said, you don't have to you could just suffer from depression, or anxiety, or anything else. You might think it's small, and you may not qualify, but you will qualify, and they have the expertise to help you with whatever mental health issue you have. Okay, now, ladies and gentlemen, the paperwork that you have, we're going to pick that paperwork up in just a few minutes. We're going to put you into one of three categories. One category is one, you want to hire an attorney, and if you would like to hire an attorney, your case will be reset today. Reset means you'll be given another court date, give you time to hire your attorney. If you would like to apply for a court-appointed attorney, if you qualify, your attorney will be appointed before you leave here. And the third category, if you like to represent yourself, you'll talk to the prosecutor. If y'all able to work out something, you'll be taken care of today. Okay, so it's gonna take us a little time to pick up the paperwork from you. If you need to use the restroom, we have two restrooms right outside in the hallway. The men's restroom is in front of County Court at 103, which is right here next door. And the women's restroom is on the opposite side of the hall in front of the 172nd District Court. You'll be allowed to go out, use the restroom, and you can come back in. Now, please do not leave the courthouse. If you leave the courthouse before your case is finished and we call your name and you're not here, guess what? Your bond will be forfeited. A warrant will be issued for your arrest. You will be arrested, placed in the county jail. And then you're gonna have to bond out again. And guess what? We're gonna have to go through this all over again. And so we're gonna try to get you in and out as soon as possible. If you need any help with the paperwork, as I mentioned to you earlier, myself and our court personnel be happy to help. Now, that first document at the top, it states the state of Texas versus, and there's a line. Please print your name on that line. And the reason why I say print is because if your handwriting is like mine, sometimes I can't read it. Okay? And just print it so we'll know who you are when we call you up. Now we're gonna put you in, like I said, we're gonna pick up the paperwork. We have our court personnel, they're gonna call you up, put you in line, and we're gonna make sure everything is done. And then once we get everybody's paperwork, then we're gonna call you up to the bench and we're gonna put you into one of the three categories, okay? Before I sit down, does anybody have a question? Yes.
When you say about the time served, let's just so say if it the final
Okay.
I was arrested in Louisiana. And I had to stay almost 30 days with it.
It should count. What we need to do is just verify. Okay, you, in essence, you're entitled to get all your time that you have a right to get all the time that you're entitled to get by law. Okay, but they had you in jail in this case over in Louisiana, and then they had sometimes, people got to be extradited here, over here. And so once they extradited over here, that time that you have there also counts, and the time that you have here also counts. But we just need to, see if we can find it in the system. Sometimes it's a little hard to find. Sometimes you have to make a phone call to the jail, either Louisiana or one of the counties or parishes. Okay, anybody else? Anybody, okay, so we get ready to go into recess, make sure you conduct yourself accordingly, we're still in court. And again, they're gonna call you up, they're gonna line you up over there, they're gonna go over your paperwork, and then after that, we're gonna put you in one of the three groups, all right? All right, go to be in recess.
If you don't, the paperwork isn't there.
Jefferson County Court at Law number 2 is back in session. First case is cause number 26 CCCR 1202. Case is style Liliana Ortiz. Ms. Ortiz is on Zoom. Ms. Ortiz.
Yes, sir.
Okay. Now, Ms. Ortiz, I think you had talked to one of the, talked to the court administrator on yesterday. Is that yes?
Yes, sir. It was yesterday.
Okay. And they said you live out of town.
Yeah, I had moved to North Carolina. It's been over about a year, and I had a better opportunity come to North Carolina. I got a better job out here, and my
Okay.
living situation is doing way better.
Okay. So, okay, this case is just 41 days old. They filed it late. Now, you need to, you'd have to come back to, your case is in Beaumont, so
Right.
you would have to come back to Beaumont to take care of your case.
Right. Yeah, I was just wondering if I could get like a little bit extended or a reset to arrange my traveling because I'd have to fly back down.
Okay, let me ask you this here. Are you planning on hiring an attorney?
I could try to, yeah. I'd still have to come back down there though,
Well,
right?
okay, well,
If I
the
do.
reason I was asking, because, you know, as I mentioned in the arraignment, you have 3 options. You can hire an attorney if you can afford to hire one. And or number 2, if you can't afford to hire an attorney, you can request that an attorney be appointed to represent you. Or number 3, our third option is you can waive your right to attorney and represent yourself. And so there's some paperwork that needs to be signed. But if you,
If
let's
I
say
hire, go ahead, sorry.
wait on, well, if you're hiring an attorney, your attorney is probably gonna have your case reset, which means you'll be given a different court date.
Huh?
Yeah, and of course, your attorney will probably be talking to the district attorney's office, doing the discovery, investigating your case as well. And depending on what the decision is based on his investigations, communications with you and the district attorney's office, whether or not he wants to, your attorney will set it for trial, or whether or not they will announce the plea, or whether, so, I mean, there's a couple of options that your attorney would have. But in the meantime, if you hired an attorney, you probably will not be required to come back and forth from North Carolina.
So if I hire an attorney, he can represent for me in court, so I won't have to go back?
Oh, you'll still have to come back.
Okay.
Yeah,
I
no,
just
I'm
won't
not
have to
saying,
keep
I'm
coming
not
back
saying
and
that.
forth.
Yeah, I'm just saying, right, I'm saying back and forth, back and forth. If
Okay.
you get an attorney here that's licensed in the state of Texas, excuse me, then it will probably solve some of your problems that you have regarding travel.
Right.
Okay. So what we can do, give us a date, 60. We're gonna reset it. We're gonna reset this case for 60 days.
Okay.
And if you hire an attorney in between that time, I'm sure your attorney is gonna contact the court through a letter of representation, and the case will probably be reset again to give your attorney an opportunity to conduct his investigation and the negotiation that he needs, as well as his conferences with you.
Okay.
Okay,
Yes, sir.
give us a date. Okay, this case will be reset to August 17th, 2026 at 9 a.m. Now, obviously, if you haven't hired anybody, you need to be in court on that day,
August 16th, you said?
17th.
17th? at 9 a.m.?
Yes. What day of the week is that? A Monday? Okay. Is that better for you on a Monday?
Yes, sir.
Okay.
And then once I get the attorney, they'll probably get a different date after that too.
That's correct?
Okay. Yes, sir.
Okay. So it's August 17th at 9 a.m.
Yes,
in
sir.
County Court at Law Number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding.
Yes, sir.
All right. So you're free to go?
Thank you so much for all of your time.
Okay, and you have a blessed day.
Yes, sir. You too. Thank you so much.
You're welcome. Session, when I call your name, the guy that back, what was his?
Right.
Oh,
You knew, yeah, I gotta put it in, I'll be right back.
where is he?
He's back there.
But you gonna have
You ready
to
for me to
bring
go?
him out? Yeah,
Okay.
he's gonna be first. Jefferson County Court at Law number 2 is back in session. The court is in session. And cause number 26CCCR 0954. Case is styled the state of Texas versus Jaqueline Jacoby Calloway. Mr. Calloway, is that your full name?
Yes, sir.
Mr. Calloway, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Calloway, you may put your hand down. How are you doing, Mr. Calloway? I'm doing fine. Thanks for asking. Mr. Calloway, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
Mr. Calloway, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Calloway, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you, in this case, is Attorney Albert Price. Attorney Price will be given information to contact you, and you will be given information to contact him. Our court coordinator will give that information to the bailiff. Now, Mr. Calloway, once you get that information, then you'll be able to go into the back with the bailiff. Now, Mr. Calloway, how old are you?
18.
18? Okay. Mr. Calloway, you probably would not believe this, but I was 18 for 365 days. Okay. Back then, you know, I see all the hair on your head. I used to have a lot of hair on my head too. Okay. But you know, over time, it went away. And I do know that you have somebody here with you. And who is that? Your grandmother. Ma'am, thanks for coming down here with your grandson. And Mr. Calloway, when I was young, I had friends, and I know you have friends too. In fact, young people these days call their friends their BFF or their ride or die. In my day, we used to call them our ace boom coon. Okay, those are the individuals that we would think that they would be with us through thick and thin. When we were down, they'll pick us up.
Yes, sir.
But on days like today, when you're here before a judge and you need a friend, them people that you call your BFF and your ride or die, they're not here. You know why? Because they got something better to do than to be down here with court and you to be down here in court with you. But that woman up back there that you call grandmother or grandmama, whatever you call her, there was nothing else in this world that would stop her from being here today. You know why? Because she loves you. Okay? That's why she's here. And I tell people this all the time, young people. Everybody is not your friend. Everybody is not your partner. But when that lady back there you call grandmama say she got you, she got you. Okay? And so I know this is not the best day in her life, having you stand before a judge. I bet that lady was the lady that probably helped to put food on the table, clothes on your back, roof over your head, and every now and then she probably had to put a little spanking on your butt. She did all of those things because she loved you. And so you might think that you know, you're in a storm, okay? But remember this, when you're walking through a storm, hold your head high. Don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of the law. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope in your heart, and you'll never walk alone. There's one thing about hope. Hope floats. So when you're drowning in the sea of confusion, don't know what to do, just hold on to hope, because hope floats. Okay? Now, You at the beginning of this process, you're gonna get through it, okay? That lady back there that you call grandmama, she's gonna be there with you every step of the way. All right?
Yes, sir.
So when you get an opportunity, you need to give her a big hug and a kiss. Thanking her for being the grandmama that she is to you. Okay. Now everybody is not like you. Some people they're not blessed to have a mother or grandmother or somebody that loves them. See, I see a lot of young people come here, don't have nobody. But you have somebody. And you can thank God for that. Okay. So your case is going to be reset. Once your case is reset, you can file a bail for you. Have a blessed day, ma'am. Thanks for coming out here with your grandson. Hang on to him. Like I say, hang on, don't hang up.
Yes, sir.
All right, he'll be all right. All right, you have a blessed day. This one. Candace Garrison. Miss, hold on a minute. Yes,
He have to bring a note, he only had 2 more days in summer school to get his diploma, he had to bring a note back to school.
just have a seat. They'll, yeah, just have a seat. Okay. Candace Garrison. Miss Garrison, your full name is Candace Danielle Garrison. How are you doing, Miss Garrison? You not good? I hope you'll be doing a lot better once you leave here. Okay? I mean, is it like a medical situation?
No, I just want the situation
Okay, well,
resolved.
okay, just relax. Okay. Yeah. A lot of times we put more on ourselves. You know, sometimes we overthink stuff. Okay. I don't know if I'm sure you like me. I don't know what the future holds, but I know who holds the future. Okay. So just like I say, just chill out. Okay. Get all of that worry from your mind. Don't even worry about it. You know, it's in somebody else's hand. Right. You'll be all right. All right. So just relax. Now, Ms. Garrison, I see here that you hired Lane Walker. Is that correct? So your case is going to be reset, and Mr. Walker is going to contact the court, letting us know that he's been hired. He's going to send us a letter of representation. And now the date that you probably get today, he may get another date because it's not unusual for attorneys to request more time to prepare. All right? So just have a seat. And your case has been reset. Once you get your reset, you're free to go. You have a blessed day. All right. Yes. Hmm? I don't know. You got to act as a grandmother.
You say he appeared here, I'm not gonna give up. I understand you, it's wrong.
Terrence Hayes. Mr. Hayes, how are you doing?
Morning.
Morning. Mr. Hayes, your full name is Terrence Jermaine Hayes?
Yes, no.
Okay, Mr. Hayes, would you please raise your right hand? You swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God. Mr. Hayes, you may put your hand down. How are you doing, Mr. Hayes? You okay? That's good. Now, Mr. Hayes, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document? And is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that state you'd like to hire your own attorney?
Yes.
Now, before you sign and initial this document, did you read the document?
Yes.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes, Your Honor.
Okay, Mr. Hayes, your case will be reset. You're gonna get your reset from our court coordinator. Once you get your reset, you're free to go and you have a blessed day. Victor Manuel Lopez Santana.
Yes, Your Honor.
All right, how you doing, Mr. Santana?
Yeah, well,
That's good. Your full name is Victor Manuel Lopez Santana.
it's good.
Mr. Santana, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Santana, you may put your hand down. Santana, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
That's correct.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Mr. Santana, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Santana, your case will be reset to give you the opportunity to hire your own attorney. You'll get your reset from our court coordinator. Once you get your reset, you're free to go, and you have a blessed day.
Appreciate it. Sir.
You're welcome.
Thank you.
Lamadra Walker. Ms. Walker, did I pronounce your first name correctly?
Lamadra.
Lamadra?
Yeah.
Okay. Ms. Walker, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Walker, you may put your hand down. How are you doing, Ms. Walker?
I'm wonderful. How are you?
I'm doing fine, thanks. So actually, Ms. Walker, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Okay.
Is this your signature on the line that's titled Defendant?
Mhm.
And are these your initials on the line that states you'd like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Ms. Walker, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Walker, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of attorney, and the attorney that will be appointed to represent you is Attorney Marcus Wilkerson. Attorney Wilkerson will be given permission to contact you, and you will be given permission to contact him. Court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
Thank you.
Please stand in front of the court coordinator. Edgar Israel Nava Santos.
Robert?
Mr. Santos, your full name is Edgar Israel Nava Santos? Santos, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may put your hand down. Now, Mr. Santos, do you speak English?
A little bit.
A little bit. That's what I thought. Hold on, you're gonna have to real point. You're gonna have to put Charles Rojas on this one. The one I had Tom Burbank on. This is Mr. Santos. information. I mean, excuse me. That's titled Judge's Explanation of Rights to Defendants Without Attorney. Ask him, does he see that document?
Yes.
And is that your signature on the line that's titled defendant?
Yes.
And are those your initials on the line that states you'd like to apply for a court-appointed attorney?
Yes, Judge.
Okay, on the next document that's titled Affidavit, Jefferson County Affidavit of Indigence, do you recognize that document?
Yes, Judge.
And is that on page 2 of that same document? There's a signature at the top left-hand corner above the line that's titled Defendant's Signature. Is that your signature?
Yes, Yes.
Okay. Now, before you sign and initial those documents, you had some help in filling out those documents?
Yes, Judge.
And now see, you have some persons in here with you.
My wife.
Your wife helped you?
His wife.
His wife?
Yeah.
Now she's fluent in Spanish and English?
Yeah.
Is that correct, ma'am?
Yeah.
Okay.
Yeah.
Now, did you understand everything in those documents?
Yeah.
Yes,
Mhm.
Yes, Judge.
Now, is everything in those documents true and correct to the best of your knowledge?
Yeah.
Yes, Judge.
Okay. So I've read your answers. You meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Charles Rojas. Okay, and he's fluent in Spanish and English. Okay. Your case is reset. Once you get your reset, you're free to go and you have a blessed day. Okay, thank you, Mr. Ross. Yes, thank you.
Yes, sir, Judge.
David Lopez. Let's see if we can. What is this one? Like somebody, you have. Janai Robertson. All right, this is gonna be an appointment.
Oh, that's the one I just gave you.
Yeah, probably. Ms. Robertson, your full name is Janaya Robinson? Okay, they have it as just Robinson. Okay, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing? I'm doing fine, thanks for asking. Now, Ms. Robertson, I have these two documents before me. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? Also, I have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, Ms. Robertson, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Robinson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney Christy Carlton. Attorney Carlton will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you're free to go. And you have a blessed day. Now, Ms. Robertson, the person that you're with, it must be your mom. You look just like her. I'm sure you heard that many times. They look just alike. Ma'am, thanks for coming down here with your daughter. Okay.
Let's see right here.
Do we have anybody? I have, wait up. I have one document, but I see at least 2 or 3 people out there. Let's see. See if we can get this.
No, they did let that boy out of prison. I'm sorry, Dad. He's something?
This is cause number 26CCR 0392. Case is filed in the state of Texas versus Sergio Enrique Sanchez. Mr. Sanchez, is that your full name?
Yes, sir.
Sanchez, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Sanchez, you may put your hand down. How are you doing, Mr. Sanchez?
I'm doing just fine. How about yourself?
I'm doing fine. Thanks for asking. Now, Mr. Sanchez, you have a right to have a court reporter to sit down, well, to type everything that's being said. You also have a right to waive or give up a right to have a court reporter. Do you waive or give up the right to have a court reporter?
Yeah, I'll wait.
Okay. Now, Mr. Sanchez, I also have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you like to waive the right to attorney and represent yourself?
Yes,
I
sir.
also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes,
Now,
sir.
Mr. Sanchez, I also have before me a document that is titled Information. This document is on my computer. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Sergio Enrique Sanchez, on or about December 7th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failed to identify fugitive with intent to give false information. Mr. Sanchez, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Sanchez, how do you plead guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means.
Yes, sir.
Okay, now, Mr. Sanchez, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishment, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are two sets of initials. First set of initials are on a line next to a box that's checked null or contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
Second set of initials are on a line next to a statement that reads, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty and no contest. Did you place your initials in the second location?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled trial court certification of defendant's right to appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Hold on a minute. Back up. And at the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand that statement?
Yes, sir.
Second box is checked states that you're waiving your right to appeal, which means you're giving up your right to appeal. You understand that statement?
Yes, sir.
Now, Mr. Sanchez, before you signed and initialed all of the documents that I showed you, did you read the documents?
Yes.
And did
sir.
you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Sanchez, are you a citizen of the United States?
Yes, sir.
State offer States Exhibit 1, Your Honor.
Mr. Sanchez, the state is offering State's Exhibit number 1 to be used as evidence in your case. State's Exhibit number 1 is the first document that I showed you on the tablet. This is the same document that has your initials in these two locations on page 2, and it also has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay. Mr. Sanchez, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay, Mr. Sanchez, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what's the agreement?
That'd be 9 months of deferred adjudication probation, $150 fine, and 24 hours community service.
Okay, Mr. Sanchez, the state is offering that you serve, let's see, 9 months. What's the court cost?
287.
2.
It's over 9 months.
Mr. Sanchez, The state is offering that you serve 9 months deferred adjudicated probation. During the 9-month probationary period, you'll be required to pay a fine of $150 plus court costs of $287. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $141 a month. Will you be able to pay the $141 each month?
Cause I also have payments in the other court as well.
Oh, you're on probation in another court?
No, sir, for the court on Northern Street.
Oh, that's a city court.
Yeah,
Okay,
city court.
municipal court. Okay. So you're not able to pay it? That's what you're saying?
Yes, I can.
If you're not,
Yeah.
it's okay. You don't have to say yes. It's not gonna go away if you say no.
No, sir, not for next month, but after that I will be, cause I'm currently getting on a job. And it takes a little while to get paid. So I won't be able to pay it this month, I'll be able to pay it after this month.
Okay, because payments are not normally due until like 30 days.
Or, okay, then yes, I'll be able to pay it then.
Okay. Now, you'll also be required to perform 24 hours of community service. And you'll be required to adhere to the other standard terms and condition of this probation. Now, Mr. Sanchez, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Sanchez, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Sanchez, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure where your record will be sealed to the general public. You can talk to attorney about the non-disclosure. Now, you're gonna stand in front of the court, well, stand next to, in front of the court coordinator, you can stand next to the bailiff. Once you follow the directions of the bailiff, you're free to go and you have a blessed day.
Quick question. About the bond, when would I be getting that back?
You have a cash bond?
Yes, sir.
Okay, you'll get that today.
Oh, today?
Oh, sorry.
Yes, you can go downstairs.
Thank you so much, sir.
All right.
Right. Just move there right quick.
Did what?
Can you mute? No, that finishes, never mind.
Yeah, Mr. Savoy, please come forward.
Right.
Okay, Mr. Savoy, your full name is LaDedrick Denzel Savoy. Mr. Savoy, would you please raise your right hand? Swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God. Savoy, you may put your hand down. How are you doing, Mr. Savoy? I'm doing fine, thanks for asking. Mr. Savoy, the state is represented in this case by attorney Farrah Nixon. Ms. Nixon, how are you doing?
Fine, how are you?
I'm doing fine, thanks for asking. And Mr. Savoy, you have a right to have a court reporter to dictate everything that's being said in court. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter? Okay, Mr. Savoy, I also have before me document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding Trial. You recognize this document? And is this your signature on the line that's titled Defendant? Okay, Mr. Savoy, I also have before me on my computer a document that is titled misdemeanor plea admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yeah.
Okay, let me do this before I go to that. Going to go to the next document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Savoy, it alleges that you the Daedric Denzel Savoy on or about March 2nd of 2025, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration of 0.15 or more. Mr. Savoy, do you understand the state's offer? Excuse me, do you understand what you've been charged with?
Yes.
And to this charge, how do you plead guilty, not guilty, no contest? Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Savoy, I also have before me a document that is titled misdemeanor plea admonishment, also labeled as State's Exhibit Number 1. You recognize this document?
Yes.
On page 2 of this same document, there's a set of initials in 2 locations. First set of initials are on a dot on a line next to a box that's checked no contingent, which means no contest. Did you place your initial LS on this document?
Yeah.
Second set of initials is on a line next to a statement that reads, I do not request discovery. I waive my right to discover in this case and choose to enter a plea of guilty, no contest. Did you place your initials in the second location? On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yeah.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. Do you understand this statement? Second box is checked, states that you're waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Savoy, before you signed and initialed all of the documents that I showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Savoy, are you a citizen of the United States?
Yes, sir.
State offers State's Exhibit 1.
Okay, Mr. Savoy, the state is offering State's Exhibit Number 1. State's Exhibit Number 1 is the first document that I showed you on this tablet. This wrong box is checked. I'm gonna correct it. It's Class A, Mr. This thing, okay. Okay, now, Mr. Savoy, this is the same document that I showed you earlier. On page 2 of the same document, your initials on these 2 locations, and on page 3, you acknowledge that your signature is above the line that's titled defendant's signature. Now, Mr. Savoy, is it all right for the state to use this document as evidence in your case?
Yeah.
Okay, no objection, State's Exhibit Number 1 will be admitted. Mr. Savoy, are you a citizen of the United States? Okay. Mr. Savoy, is there any evidence that you are currently mentally incompetent to stand trial? None? Okay. Mr. Savoy, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
The essential terms are as follows: 180 days in county jail, probated over 15 months, a $750 fine, 60 hours community service work, interlock device, a DWI first, and dismissing case 25 CCCR 0829.
What's the court cost?
337.
Okay. Mr. Savoy, the state is offering that you serve 180 days in the Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 15 months. During the 15-month probationary period, you'll be required to pay a fine of $750 plus court costs, $337 plus a DWI conviction fine fee of $100. You'll be required to pay probation fee of $6 a month, your announcement fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you are required to pay each month, is $166 a month. Will you be able to pay the $166 a month? You'll also be required to install an interlock device on any vehicle that you own or operate, attend and complete the DWI education class, have an alcohol assessment, and adhere to the other standard terms and conditions of this probation. And the state will be dismissing the companion case, cause number 25 CCCR 0829. Mr. Savoy, do you understand the state's offer?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Savoy, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Savoy, you're gonna stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day.
Okay, you too.
Thank you.
Thank you.
No, he died. Yeah, when they released it. I thought it was March.
Ms. Balthazar, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Balthazar, you may put your hand down. Ms. Balthazar, your full name is, what's that? Deja?
Yes.
Deja Jasmine Balthazar? Ms. Balthazar, how are you doing? I'm doing fine, thanks for asking. Balthazar, I have two documents before me. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yeah.
And is this your signature on the line that's titled defendant? And are these your initial on the line that states you'd like to apply for court-appointed attorney?
Yeah.
The next document is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yeah.
And on page 2 of the same document, there's a signature above the line that's titled defendant's signature. Is this your signature? Ms. Balthazar, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Balthazar, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is attorney Jennifer DeLedge. Attorney DeLedge will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you will be free to go. And you have a blessed day. Please have a seat in that first chair on the wall. Okay, this will, Jefferson County Court number 2 has ended its session. Everyone please have a blessed